Hey guys, and welcome back. So today we will be dealing with a question we get very often, and we want to solve those questions that you have. So recently on our giveaway video we got a question saying how should we go about incorporating the Bareact in the mains answer writing. Should we use the entire Bareact or a part of it or the concept? So that is the question we will be dealing with today. How much of the Bareact do you need to reproduce in the mains answer writing? Should you write the entire section, just a part of the section, ingredients, write the concept as you understand it, or just an operative part of the section? And for this, what we are going to do is take section 32 of the Indian Evidence Act, which is dying declaration, as an example. So we have done a full video series on dying declaration. If you don't understand the concept of dying declaration, you should watch that series, which we will link on your screen. Today we will not be dealing with the concept. We will not be explaining dying declaration to you. We will just be taking it as an example that if you get a question on dying declaration in the mains exam, then how much of the Bareact should you write in the exam? So for that, let's take a look at section 32 of the Indian Evidence Act, which is the dying declaration. And in that, in clause 1, it provides when it relates to the cause of death when statements are relevant. For this, let's take a hypothetical example. Let's take an example where the dying declaration was made by a person, but the defense says that the person was not under expectation of death at the time of making the dying declaration, and hence the statement should be dismissed or should be considered irrelevant. And you have to give a judgment on it. As a judge, you have to think about it, that this is the argument of the defense, whether the statement will be relevant or not relevant in this case. Is expectation of death essential? You have to think about the reasoning, you have to think about the concept, you have to think about the section. This is the question that you have to write a judgment on, that whether a statement which was made without expectation of death is relevant under section 32. This is the hypothetical question which is given to you in the question paper. Now you have to write the law on it, you have to write the issues on it, you have to give the reasoning on it, and you have to give a judgment on it. So what will you do? Will you write the whole section? Will you give the ingredients of the section? Will you explain the concept of dying declaration? So in this question, first you read the section. And when you read the section, you will see that it says that when a statement is made by a person regarding the cause of his death or the circumstances of the transaction of his death, in which case the cause of the person's death comes into a question, such statements are relevant whether the person who made them was or was not when it was made under expectation of death. So it says very categorically that the statement is relevant whether the person was or was not under expectation of death. This is the operative, this is the main part of the section which is applicable to the current problem which is given to you, in which the defense is saying that the statement should be irrelevant because the person just made it casually. They were not under expectation of death. They just made a statement regarding their death. So this statement should be regarded irrelevant. This is what the defense is saying. But on a bare reading of the Bareact, just a simple plain reading, you can see that it says very categorically that the person, it does not matter whether the person was or was not under expectation of death. So this is the operative part of the section which comes into play, which you have to show in your answer that the section says this very clearly. So the argument of the defense is irrelevant. The argument of the defense is wrong. It does not matter whether the person was or was not under expectation of death. In this, we are not going into case laws. We are not going into any sort of interpretation. We are keeping this very simple, and we are taking an example where the Bareact solves the question itself. So in this, what you will do is you will take these words, that whether the person was or was not under expectation of death, you will put them in inverted commas and you will put them in your mains answer. You do not have to reproduce the entire section. You do not have to reproduce the ingredients. Only this part, that the person was or was not under expectation of death, is the operative part. When you put this part in the answer, it will show to the examiner also that you understand exactly where in the section the answer lies. You can pinpoint exactly what is applicable to the current problem. You can distinguish the important part from the unimportant part. You can think like a judge. You know exactly what part of the section is applicable in this case. So you just have to take these two parts, was or was not under expectation of death, and you put it in inverted commas and you put it in your mains answer. You don't write the entire section because that will only waste your time, and it will also waste the examiner's time, and the examiner will actually think that you are trying to make up an answer. So you just take the important part, which is was or was not under expectation of death, and you put it in inverted commas in your answer. You don't have to write the entire section. You don't have to write all of the ingredients. You have to take the problem, you have to analyze it, you have to talk about it in a couple of lines, and then you will say that this is the part of the section which is the operative part. You put it in inverted commas and you show that because of this part of the section, the statement still remains relevant, and you give your judgment on it. You don't write the entire section, only the operative part. And this is not just in case of dying declaration, it is for any section, be it CPC, be it limitation, be it contract. You use the inverted commas and you put the operative part. This will also save you time, and the people who are checking your papers are well read. They are mostly high court judges or specialized examiners, and in those cases they know the Bareact. If they wanted to read the Bareact, they could have just opened the Bareact and read it. If you write the whole section, this will actually be a negative in your case. So you just put the important parts in the inverted commas and you say this is the operative part, this is the part of the section which is relevant to our problem. You will of course do this after discussing the law, the issues, and then you will give your reasoning, and then you will give your conclusion as to whether or not the person who made the statement, his statement is dying declaration or not, whether it is relevant or not. Whatever is the conclusion, you will give your judgment on it. But you will discuss the law, you will discuss the issues, and we have discussed all of this in the foundation course, that you have to discuss all of these things in what order, what a material you have to put under each heading. But the most important part of the answer is the reasoning, where you show them that you can think like a judge, where you show them that this is the reason why the judgment goes one way or another. This is the reasoning. This is where you show the deliberation. This is where you show the application of mind, the judicial application of mind, where you show that you thought like a judge, you imagined what the problem is, you understood the section, you understood the concept. If there is a case law, then you write that also here. So reasoning is the most important part of the section. And in this reasoning, you want to save time, you want to show that you understand the section, you understand the concept, and you're not just reproducing the Bareact. You haven't just done rote learning and reproducing the Bareact. You understand the section and you can pinpoint exactly where the problem lies. So you just take the operative part of the Bareact, which is was or was not under expectation of death, and you put it in the reasoning. Of course, if you have a case law, then you put that also here. If you have more supporting cases, you put that here. This is the part which will give you the marks. So this is how you take the Bareact and you incorporate it in your answer writing in the mains. You don't reproduce the entire Bareact, you don't reproduce the entire section. That will only give you a negative. That will only prove harmful because you will just waste time. The judges don't need to learn the Bareact from you. They need to learn whether you can think like a judge or not, whether you can pinpoint in the Bareact where the answer lies or not. And we understand this is a very common problem. So we hope this helped, and we implore you, we request you that if there are any questions like these that you face on a daily basis, that you wonder about, that you don't know the answer to, please tell us. please leave the questions in the comments, and next time we'll make a video on those questions, because we are always looking for questions to solve, and we try best to make videos which we think that you will find helpful, but we obviously don't understand it from your perspective. So if there are any questions which we haven't covered, which you think about, which you think how to do this in the exam or how to prepare for this part of the exam, any questions, leave it in the comments. We are more than happy to solve these questions for you. We hope you learned something. Make sure you hit the subscribe button, and we will see you soon.